Ladies and gentlemen, it's 7:01 p.m. We're going to call the Castle Hill Zoning Commission meeting to order. It is September 5th, 2017, City of Castle Hill Zoning Commission meeting at 7 p.m. It's Castle Hill City Hall, City Council Chambers, 209 Lemonwood Drive in Castle Hills, Texas. We do have a quorum in attendance. The commissioners seated tonight from my right are Mr. Aiken, Ms. Baker, Mr. Fentress, Mr. Flynn, Chairman is Brand. Item number 2, consider approval of the August 1st, 2017 Zoning Commission minutes. Members, you have those minutes before you. Do you have comments, edits, anything like that? And if not, we'll take a motion.
One change, if you can change the spelling of my last name. That's all. Just like that all the time.
Despite that egregious effort, is there a motion to approve the, egregious error rather, is there approval to, we have a motion from Mr. Aiken, spelled correctly, and a second from Ms. Baker. All in favor? Unanimous. Thank you very much. Item number 3, consider the application from the Christian School of Castle Hills located at 2216 Northwest Military Highway to amend Chapter 50 zoning, adding 5, day nursery, preschool, or kindergarten in conjunction with a public, private, or non-denominational school having a curriculum equivalent to grades 1 through 12 of a public school at the end of Section 50-497A, and to repeal Section 50-497B1, and to renumber Section 50-497B accordingly. Ms. Thailing, has all the requirements regarding public notification been met on this? Thank you. Then we'll hear this matter. We'll open up the public hearing and first ask the applicant or their representative to come forward to address the commission on this matter. Sir, if you could please identify yourself and take it away.
Yes, greetings to the commission, and my name is Michael Pinkston. I'm the superintendent at the Christian School at Castle Hills, and I'll be making the petition on behalf of the school this evening. Thank you for your service in reviewing our proposal. And we'll keep this simple and straightforward. The background on our proposal, in January 1st, 2016, after 55 years of being a part of Castle Hills First Baptist Church, our school became a separately incorporated independent school. At the same time, we entered into a 3.5-year lease purchase agreement with the church for 3 of the 4 historic buildings that the school had operated in. We accomplished this and also the land immediately behind those buildings. And then we accomplished this move, this transition, by reconfiguring our campus from those 4 buildings into 3 buildings. And part of that was moving our preschool from its historic location in what's called the Faith Building, and then renovating a building called Hope that you'll see up there. You'll see inside where it says school facilities. Dan, there you go. It says Victory, and then Hope, and then Love. And the Hope building is the building that we renovated and moved the children from the previous building, which would be just to the north of that or just to the right if you're looking at the screen. And moved them in April of this year. And through that process, we, working with city staff, even talking to some council members, we were just asking, are there any T's we need to cross, any I's we need to dot? And the thought or the idea of potentially approaching the zoning commission on a special use permit was brought to our attention. And so, through this process, we got guidance from city staff, very helpful city staff, and advice from others. And then we, come tonight to approach the committee or commission with the special use permit request really for two purposes. One, to allow the continuation of the K-12 school, preschool, and preschool that's have historically occupied those premises, actually since 1961, when the early childhood program in the kindergarten was started. And then the second was to ask the commission to request the city to amend the zoning code as stated in your reading of section 50-497 to include the opportunity to request a designation for special uses for day nurseries, preschools, or kindergartens in conjunction with the public, private, or denominational school having an equivalent of up to grades 1 to 12, which we do. Related to the site plan that's above, I guess the only other comment, there's really no change of use. We'll be doing the same thing we've been doing. If you look at the history of the school, 1961, the early childhood programs were started. The elementary program was started in 1981 with secondary grades added 1 year at a time. First graduating class, 1987. 1,000 graduates since that time, dotting the globe, serving their communities and the Lord. And then January 2016, we became an independent school. Those are kind of the historic dates that kind of, you can kind of hang some of the story or the narrative on. In closing, we just we approach you with this request for a special use permit that allows us to continue the mission to reach, teach, and train boys and girls and teens, hopefully for another 56 years. And thank you for allowing us to put this request before you. And if you had any questions or I could be of any help, I'd be glad to do that.
Thank you, sir. And just for clarification for particularly those in the audience, that there's two items that we're considering tonight. This first one is on the amendment to the zoning chapter 50. The second one will be actually on the SUP, so just so you're aware of that. Before we actually open the public hearing, let me first ask the members of the commission if they have any initial questions. Mr. Aiken, do you have anything? Ms. Baker?
What is your intent to do with the preschool once basis is gone from the church property?
We're basically configured the way we intend to be configured because those are the buildings that we're purchasing from the church.
Was there any purchase of the preschool entity itself?
Oh, the preschool and the school are one entity. Historically, many years ago, they were separate entities, but today, in its present form, the preschool and the K-12 school are all one entity.
Does your request for the changing of the zoning and an SUP include the Grist property, the
No,
other
ma'am.
properties that you purchased?
No, ma'am, it does
Okay.
not.
It concerns me because they are listed as the property that you own. And
Yeah,
if you
we do
get an
own that
SUP
property. At this point in time, we don't have a plan, any plan for that property. These are the properties that we're owning, working to own, and this lease purchase agreement that we're in. And it's the properties that we know and intend to use. If that were ever to change, we would have to come back, I'm sure, before you and look. At this point, there is no plan for that property.
So you're willing to limit your SUP to only the physical property as it exists and you currently are leasing and
Yes,
subject to
ma'am.
lease purchase?
Yes, ma'am.
My concern is that you're asking us to change a zoning law that would invite the opportunity for other commercial enterprises to put daycare centers on residential property. And I understand that the daycare center's been there for a long, long time.
Yes.
And that traffic-wise and perhaps use-wise, there's no change, but your request is broader than that because you want us to change the zoning laws. And so I have some reservations about doing that, but I don't know how to accommodate allowing the daycare center to continue.
Yes, ma'am.
So I don't know what the city advised you, or what the city attorney would advise you, if there is another option.
Yeah, I mean, the course that we're taking are the steps that the city advised us. We're operating off of just the counsel and advice. We haven't spoken with the city attorney about this, so I wouldn't be able to answer that.
Would you be willing to limit within the request that if there is one that's issued for an SUP, to limit it to the specific property and not to any new development? I'm sorry if I'm not making myself clear.
Yeah, so would you mind restating that?
I want to know, will you restrict the use? If an SUP is granted to you,
Right.
I want you to say now verbally, and verbally amend your petition to limit it to the physical property you are under lease purchase with now, and not for new development.
Yeah, and I'm just, I think that's what my proposal actually, I think my
Well, when you
proposal is
listed
to
the
that
grist,
end.
when you listed the grist property, to me, that subjected it
I
all
didn't
to an
list it, I
SUP.
just didn't want to negate the fact that we own the grist property. I bought the grist property, we bought the grist property, not knowing at the time early on back in a little over a year ago when we purchased that property, what the future of the school would be, what the parking, parameters and requirements from the city would be. The property came available, and it was a safety valve for us because, we didn't have a place to go. We didn't have any land. We didn't own any buildings. And the church graciously gave us this opportunity to purchase the properties, but not knowing, I didn't have we didn't have a working knowledge of what would be required of us in the future. And so I don't think I'd want to tie myself into, if I was asked of something that I needed that property for instance, if I had to have a certain number of parking places or something to that degree that were to change, I would want that. I think I'd want that option.
So
does
the
that make
answer is
sense?
no.
Yeah, well, I'm just telling you, the answer related to my proposal is for exactly what you're asking for. And I'm not asking for anything more than what you're asking for. If there was
So
ever a
just to-
time,
Just to clarify, Ms. Baker, I think that based on the way, and this really gets into the SUP portion, not necessarily on the zoning language change, but the way that the SUP portion is worded, it's tied specifically to that lot. I don't think it could be applied, and I'll ask Mr. Brennan to confirm, could be applied to the Grist property. So in other words, what Mr. Pinkston is saying is, if they, at a future time, determined they wanted to use the Grist property a particular way, they would have to come back for an additional SUP in order to do that. So is that true, Michael?
Yes, Ms. Baker. Of course, we didn't give legal advice to the church or the school as to how to approach this thing, but when we were reviewing the code, the day school and nursery was not a permitted use in residential, nor was the high school and private school, I don't think, without an SUP. The day school was not permitted at all. As I recall it, the high school and private school and so forth was permitted in a residential with an SUP. So our thought process was, if the code could be amended to authorize daycare, school, high school, and all that with an SUP and a residential, that would be a way of accomplishing what needed to be done, but still retain maximum control of the use of the property by the city. Because, as you know, SUPs are far more encompassing, far more detailed, far more thorough as a zoning tool than just a plain old zoning code amendment. Because if you walk in with a project that's authorized in A zoning. If you fit in A zoning for your project, you can do it. And the city has very little control other than to make sure that you're doing an A authorized project. When you have an SUP for any project in whatever zoning district it is, the city writes the ticket, so to speak, as to how long that will exist, what the parameters are. If there's a change in ownership, the SUP expires. A change in use, the SUP expires. So the city can make its own blueprint of what the SUP use will be. So our feeling was, as a staff, that with that control in hand, if the zoning commission and the city council viewed this project favorably, they could do it through an SUP over which they would have total control over as to what it says and how long it would last and who could do it and all that you cannot do in a regular zoning district. So that's kind of how we ended up where we are right now.
So, Mr. Brennan, if the commission and accordingly the council next week were to decline to amend Chapter 50, that doesn't necessarily preclude the applicant from moving forward with the request for the SUP, is that correct?
They could move forward with the SUP application for the school, is that not right, Jen? For the school, but not for the daycare and nursery, because that's not authorized at all under any circumstances in an A residential district.
Mr. Chairman, may I interject here? It seemed like we're combining two items here, so we're getting out of order. So I would suggest we just stick to item 3, which is the zoning discussion, and limit that discussion to item 3, and we'll hold off on the SUP, and we deal with those separately. And while I'm saying that, well, I guess I may be getting ahead of myself because we haven't had the public hearing, but I have a problem with the process that we're going through for revising the ordinances. And that also pertains to the Wedgewood discussion. We are sitting here, and between us, we have a committee going right now to change the zoning ordinances. And here we are circumventing that process to change the ordinances. And I think that creates a bad precedent, because going forward in future zoning commissions, are we going to be constantly tweaking this thing as we go along? That seems to me to be somewhat arbitrary. And so if we're going to do this, I'm right now going to vote against item 3.
Thank you, Mr. Flynn. And that's actually one of the reasons why I asked about the applicant's request for the SUP, because I feel I share your concern. And I guess the one question I would ask you, sir, is did you intend, when you brought this matter to the city of Castle Hills, to pursue a change in the zoning ordinance for this city?
Did I intend for there to be a change in the zoning ordinance? My understanding is that's what it would take in order for us to acquire the SUP.
Okay,
That's just-
I just wanted to understand your
Right,
understanding
that
of
was
it.
my
Okay, thank
understanding.
you. Ms. Baker, did you have other questions or comments?
Well, I agree with the concerns that taking it out of order, but for me, they're very much entwined. And I can't approve of one without knowing what the intent is on the other. And so I do apologize. It was disjointed and out of order. My question now is that, so if you've been functioning with a preschool, then you've been functioning all these years without the proper authority?
Ms. Baker, it's our understanding that the church had owned and operated all of this historically, and if there were code amendments which made it not feasible, they were grandfathered and were a non-conforming use according to the code as it currently exists. And that's why when there was a change of ownership of the property and the entity, they could no longer operate under the umbrella of the church since they were now a freestanding entity. And in order to get a certificate of occupancy, they had to have legal authority, and this is the only route that we could simply, or come up with simply, that still protected the city to accomplish that goal.
Thank you for that clarification. I appreciate it.
Mr. Fentress, did you have questions or comments?
I want to see if I'm understanding this correctly. I apologize if this is a foolish question, but so what we're saying is that we have to change the zoning law in order for them to ask for the SUP. But if we change the zoning law, does that open us up to be sitting here every month talking about nurseries moving into houses next door? Is that our major concern?
That certainly is mine.
My question is, can we prevent that? I don't have, currently, I don't have any problem with them staying and doing what they've always done. They've been great neighbors, and I don't know which building they're in, frankly, as I drive by. It's not a nuisance, it's no inconvenience. But I do understand we've got to find a legal way for them to continue to do it that doesn't cause the city major headaches for years to come. We've been trying to find a way to simplify that so we don't have to repeat ourselves that much.
Mr. Chairman, could I make one response to his question?
Yes, sir.
The wording that we came up with as a suggestion to you all was that to avoid the problem of everybody's house becoming a daycare nursery, was that under this wording, it has to be tied to a school with a 1 through 12 grade curriculum. So that the only way they can get a day nursery is if they're also operating a curriculum 1 through 12 school at the same time.
That does make me feel a lot better.
Good, thank you.
Anything else, Mr. Fentress? No. Mr. Flynn, did you have anything else? All right, thank you, sir. It's 7:22. We're going to open up the public hearing on this item now. Ms. Thalen, did we have signups to be heard tonight? All right, we'll go to citizens to be heard then. Again, we open up the public hearing at 7:22 p.m. Robbie Casey. Okay, thank you, ma'am. Stephen Ackley, Dr. Ackley. Okay. Ms. Winger.
Thank you, Mr. Chairman. I'm a little bit confused if I'm on the right number, so if I'm not, you let me know because I may have been confused.
And I apologize because I didn't look at the agenda numbers before I started calling people
Okay,
here. So
okay.
we're on item 3.
And that's what you've been discussing?
Yes, ma'am.
Okay. And so are we discussing the daycare center?
Yes,
or
ma'am.
not?
We're discussing the proposed change in the zoning ordinance. We have not gone to item 4 yet, which would be specific to the SUP.
For the same thing or not? Is it? is
One is a proposed change to the actual ordinance. Then based on the outcome of that, it would be a request from the Christian school for an SUP to operate.
Okay. But why I'm confused and why I just added my name to this is that Ms. Baker was bringing up the issue of the Grist property. And that's really what I wanted to address. Aside from the fact that Mr. Brennan has already pointed out that daycare centers are not allowed in a residential, so I don't think I have to speak to that. That's what I want to talk about, is that property. Is that property under consideration now or not?
It has been mentioned in in the presentation
So
that the Christian school made, so we'd be open to hear your
But
comment on it.
I'm simply asking if this is an appropriate time to address that, or if I'm out of order.
That's what I'm saying, ma'am. It was addressed in their presentation, so yes, it would be
So
an
it's okay.
appropriate time. Yes,
Okay.
ma'am.
What I wanted to bring up is that, as you all know, there's a federal court order that pertains to this property. Its name changes do not change the fact that this school is the same school that was always there, and it was part of the Castle Hills First Baptist Church. And as far as I understand, they're still the owners. They're simply, the Christian school is buying out their portion of it, but it still applies under the federal court order. The federal court order does not permit any extension of the footprint that existed at that time. So that's something that you need to take into consideration with the Grist property. That's all I wanted to bring up. Thank you.
Okay, thank you very much. Are there others to be heard? Since I misread the agenda items, maybe I missed a name or two. Anyone else want to be heard on this? All right, we will close the public hearing at 7:27 PM. And let me go back around. Members, are there other questions to the applicant, other comments or discussion you would like to have before we entertain a motion on this? Ms.
I
Baker.
guess I'd like some clarification from Attorney Brennan. If we change the city zoning ordinance to allow daycare centers associated, I forget where my question's going, I'm sorry, daycare centers only with public schools, it still subjects possibility that residential property can be acquired by a school-like basis and become daycare centers? Is that what I'm understanding?
I think that's a possibility. I don't know how realistic it is, but it's a theoretical possibility, because if this amendment to the code is made, then a daycare, nursery, preschool, or kindergarten in conjunction with a public, private, or denominational school having a curriculum of 1 through 12 of a public school curriculum, if one of those entities came to the city and asked for a special use permit, they would be able to ask for that. Certainly doesn't mean that they would be granted that, but they certainly would have the right to ask for that, for an SUP, right?
Other comments? I guess what I'm still not clear on in my mind, and I think it leads to the questions that you're asking, is this says public, private, or denominational school. So we all know the challenges that this city and other cities have regarding those institutions that are able to acquire land without regard to current zoning or neighborhoods and put facilities in there. And then if we were to approve this amendment, that it then allows on top of that for them to add the additional daycare facilities. So it's not just, in the specific example that you say, it's not just a first through 12th grade, but then, it gives them the flexibility, if you will, to add even more. And I think that's problematic. I think that's very problematic. I'd also like to go back to Mr. Flynn's comment earlier that I always have apprehension about an amendment to our ordinances that's a one-off, if you will. And we've had a committee that has been working for quite some time, and this commission has been working for quite some time to go page by page, line by line with them to look more holistically at it. Yet in this case, we're asked, or the expectation would be the need to change the ordinance in order to accommodate this request, which was why I was asking the question, could this proceed with an SUP without a change in the ordinance? Because I think that's two different cases, at least in my mind. But I think these are problematic issues that are raised here.
Thought, would it change or would it solve our problem if we could incorporate something that was basically something of a grandfathering clause, where you had a situation like this where it was almost the same owner that was asking for continued use? That wouldn't create problems with future properties. and yet you could be consistent with leaving it as a rule in the zoning code.
I think the challenge there, and it's a good thought, thank you, is that there is in effect a grandfather. There has been a school in operation there. But this is expanding the parameters of it in the location that it would be.
Well, I guess my question then is there a way that we could make this specific enough that it doesn't create future problems on other properties, but could become a rule that could encompass this? In other words, how close of a grandfather could we create as a clause that we could make it universal? That it would still cover, that it would cover this, we could widen it enough to cover this, but narrow it enough that we don't have problems with future properties.
So I appreciate your intent. It gives me a little bit of, more than a little bit of concern to think about writing zoning ordinances that accommodate one individual, one business, one resident, one whatever. I think you start to go down a slippery slope if you do that. Mr. Flynn?
Let me play the devil's advocate here. I mean, and I agree with it, you know, you start doing the one-off, I think that just opens up a real can of worms. But we've granted waivers on different ordinances, have we not?
I would ask that of the city manager or the city attorney.
I'm not sure about the waivers. I'm sure you're thinking of one that I'm not thinking of. A Board of Adjustment, can waive or grant variances for minor issues regarding, or waivers, if you want to call them that, to requirements of the zoning code, but they can't grant use variances. And what we're talking about here are use waivers. What we're talking about here, I don't know of an entity in the city that can just waive the code as far as use purposes are concerned. And in answer to your question, the chairman's right. Your suggestion is a decent suggestion. Is there some way to restrict the new wording to historical or grandfathered type or long existing uses? And to convert that into words to put in here, I'm not sure exactly how we would do it. I think it's possible. I'm just not sure what the right words would be.
Because we would have very few examples of that here that could exploit it. And so it wouldn't really be a one-off. It would just be something that we don't have any other examples of that we could foresee. So it would really be limiting, but it could still be very, very general.
Yeah, I think the clause is as we could foresee right now. All right, if there's no other discussion, we'll accept a motion on this.
Can I bring up one point?
Yes, sir, Mr. Aiken.
Kind of going off what Thomas said. So the city attorney added the wording to tie the kindergarten with the rest of the public school by adding the words in conjunction with a public, private, or non-denominational. If we added the word in conjunction with an existing public, private, or denominational school, haven't we then done what you're saying by adding one word and changing the word a to and then we tie it into existing schools that are already here? That in effect grandfathers it, but it doesn't make it a one-off. I think it's workable.
Let me ask the city attorney.
I think that's a brilliant suggestion. I don't know what y'all think about it, but that accomplishes what you were suggesting, sir, and I don't see any legal problem with it. In fact, it's very clever.
Any discussion on that?
Could you repeat what you just suggested?
So if you read the motion, consider the application, go to the third line, or go to the actual motion, a 5-day nursery school, preschool, or kindergarten in conjunction with an existing public, private, or denominational school. So we then tie this into the existing schools, our existing 1 through 12 schools already located in the Castle Hills. So it wouldn't open us up to any more day schools without someone coming in. It wouldn't open us up to any more Well, it wouldn't open any more day schools coming in without them coming before this committee. I think. And that's where I'm trying to get us to. So it grandfathers it without being a specific grandfather, if you will, to this one school by adding the word existing. It looks like a fix to me.
Other comments before I ask for a motion? So we don't have a motion on this yet, so Mr. Brennan, make sure police me on this. So I could accept a motion that would include that language incorporated.
Yes, you know, y'all's general authority on agenda items is you can't really make them bigger than they already are, but that actually makes it more restrictive than it already is, so that would be appropriate.
Okay, so just so we have the level setting there of what our possibilities are here tonight. All right, so with that said, open to a motion.
Well, I would make a motion that we, do I need to read the motion, or do I just make the motion to what we just changed it to, adding the word "and existing"?
Why don't you make the motion that we recommend, if you're going to recommend approval, that we recommend to council approval and read the language as you would want it to be?
Just need to sit you over here, let me sit over there, and we'll be done with this. So I'd make a motion, I'll make a motion that we make a motion to recommend this motion as, with the new language of an existing, and I messed that all up, and my apologies, but I think you know where we're going.
Okay, is there a second to the motion?
I'll second.
A second from Mr. Fentress. The motion is, we recommend to council the amendment, amending Chapter 50 zoning, adding day, nursery, preschool, or kindergarten in conjunction with an existing private, public, or denominational school, et cetera, to the rest of the read there. Is everyone clear on what that motion is? So we have a motion and a second. Is there discussion on this motion?
Again, you know, I agree with I think your suggestion is very valid. But again, I have a real problem with the procedural aspects of this. And over time, I mean, that's some of the problems that we've seen with this city already. Not so much maybe with this, although we did have a hodgepodge type ordinance that's taking a massive effort to revise. We also it also goes to zoning issues. You know, we still don't have a master plan, and so everything's on a one-off basis, and it's constantly being tweaked, and I just have a real problem with that. I think it opens us up to problems down the road. I think it opens us up to corruption charges. You know, maybe I may be over-speaking, but, you know, if somebody, developer came in here and, you know, wanted to make a change to the ordinance, who's to say 5 or 10 years from now he couldn't offer enough money? Say, yeah, okay. So I just have a whole problem with this procedurally, so I'm going to vote no.
All right, are there other comments or discussion? No other comments or discussion? We'll take a vote. All in favor of the recommended amendment, amendment made by Mr. Aiken, signify by raising your hand. All in favor of it? Mr. Aiken, Mr. Fentress, and I'm going to vote in favor of it. And it will move to, this is a recommendation to council. I'm voting in favor of it because I believe that when we get in some of these sticky situations, I don't disagree, but I do believe that we should give the deference to council on it. So item number 3 will be moved to city council. Item number 4, consider the application from the Christian School of Castle Hills located at 2216 Northwest Military Highway, legal description CB 5778, Block 1, Lot 29, for an SUP for a day nursery, preschool, or kindergarten in a denominational school having a curriculum equivalent to grades 1 through 12 of a public school. Would the applicant care to comment on this any further? All right. Okay, thank you, sir. Are there initial comments or questions from the commission? Mr. Flynn?
So as I understand this, this is primarily an administrative change. The school exists, the buildings exist, there's not going to be any change in usage, so this is strictly an administrative discussion as far as I see it. Am I correct in my interpretation? Okay.
Mr. Aiken?
Let me ask one question. So the discussion earlier, when we were kind of combining these two, was related really to the, I think mainly to the Grist property, and could they expand? So I guess for clarification, the SUP is asking specifically for City Block 5778, Block 1, Lot 29. So I think the question is where is Lot 29? And I presume the SUP is only good for that lot. And if that's the case, then we don't have to worry about the Grist property. And I'm not sure who I'm asking to, someone down there.
Yeah, that's correct. This is specifically written for their current location, not the Grist property, but the property on Northwest Military.
And that is the property that I guess we see in yellow, is that right?
In the bottom block where it says school facilities under contract, yes. Specifically, this is in the Hope Building, isn't it, Mr. Pinkston? The actual daycare and nursery is in the Hope Building? Yes.
Okay. So that's excuse me, that's Lot 29.
That's correct, and it's specific solely to that.
Mr. Chairman, the city manager said specifically the Hope Building, but really this is all of that property that says school facilities, not just, the SUP will be for the preschool and the other school, the curriculum 1 through 12 school. Correct? Is that right, sir? Yes.
Okay, thank you. Ms. Baker?
I'm sorry, Mr. Brennan, but you just can't, I'm easily confused. Is what you just said is that the SUP would be limited to the physical property that exists, not to include the Grist property? Is that correct?
That's correct.
Thank you.
Other questions, comments at this point? All right, it's 7:43 PM. We'll open up the public hearing on item number 4. I'll see if I can get this right. Ms. Casey, did you want to comment on this one? Yes, I did. Would you please approach the podium?
As we all know that, well, let me introduce myself. I'm Robbie Casey, 144 Cass Hills Drive, San Antonio. And as we all know, the Wedgewood has been sitting there vacant for quite some time now. And I had the opportunity to tour the property last week.
Ma'am, I'm sorry, we're not to the Wedgewood yet.
Oh,
We're
you
still
said-
on the school. We're on item 4, the SUP.
Oh, I'm sorry. I thought we
But
had gone on to the Wedgewood.
we're not speedy enough yet on that, but
Okay.
we'll
All right.
happily
Well,
call
I
you
don't
back
have
up
any-
shortly.
I'm going to pass on the
Okay,
school.
thank you.
Thank you.
She's going to be ready.
Dr. Ackley, did you want to comment on this one?
Stephen Ackley, 118 West Castle Lane. I think my major concern is that, and it probably is in the form of a question, is that is there anything stopping the church or the school from putting a driveway contiguous with the Grist property and exiting traffic onto West Avenue? My own look at this is, they're not asking for an SUP, but it seems to me that that would be something that they could do because they own all the properties right there. And, based on our current situation with the traffic on Northwest Military and as well as the traffic going into the daycare from both the basis and the church, to then dump that traffic, some of that traffic down through West Avenue, I think is a very major problem because it's right in front of St. George's and it would further clog up that intersection. So I think we're hamstrung on this, but I would like the opinion of the city attorney or the And if some restriction can be put that there can't be a driveway in between the present school facility and the Grist property, that would be, I think, a major assistance in this. If it can be done, it should be done. Thank you.
Thank you. Mr. Brandon, did you want to respond to that?
Any use of the Grist property is going to have to come to the city for something, you know, whether it's an SUP, a zoning change, or whatever, you know, possibility that is different than what it is today. So if the school decided they wanted to connect the school property with West Avenue through the Grist property, they'd have to come back to you all for an SUP to either tag on or a separate SUP for that use.
All right, thank you, sir. Ms. Wenger, did you want to comment on this one? Thank you, ma'am. Is there anybody else who hasn't signed up but would like to comment on this? All right, it's 7:47 p.m. and we'll close the public hearing portion of this and open this back up to discussion by the commission. Is there any other comments or questions that any of you would like to put forth at this point? All right. Hearing none, we'll entertain a motion on this one. Do we have one?
I motion that we put forth to the city council that we consider the application from the Christian School at Castle Hills located at 2216 Northwest Military Highway, legal description CB 5778, Block 1, Lot 29, for an SUP for a day nursery, preschool, or kindergarten, and a denominational school having a curriculum equivalent to grades 1 through 12 of a public school.
All right, we have a motion. Do we have, from Mr. Flynn, do we have a second?
Second.
Second from Mr. Fentress. Is there any other discussion on this? All right, hearing none, we'll take a vote. All in favor of the motion is put forward by Mr. Flynn. Please indicate by raising your hand. And all opposed? It'll be 4-1 in favor. That recommendation will also go to City Council. Council meets next Tuesday, so this would be on the agenda for their final review. All right, moving on to item number 5. Consider the application from Wedgewood Senior Apartments, LLC, to repeal Section 50-2253, which establishes a minimum size for apartment units, to amend Section 50-227D3 by reducing the minimum lot area for high-rise apartments from 1,500 square feet to 800 square feet per dwelling unit, to amend Section 50-227F by reducing the minimum off-street parking spaces required from 2 cars for each dwelling unit to 1.3 cars for each dwelling unit, to amend Section 50-228A by exempting front yard fence height limitations from the applicability of Section 50-66 to the D high-rise apartment district, and by repealing Section 50-28B. Ms. Thalen, have all the requirements regarding notification been met on this one? Thank you. And so we'll ask the applicant if you could please identify yourself and give your presentation to the commission.
Mr. Chairman, thank you very much. My name is Bill Kaufman. I'm here on behalf of the owners of the Wedgewood, and we'd like to go over our request and kind of explain it. There are some similarities to your prior case, but there are also some distinctions. This is an aerial of the site. I think you're all familiar with it. It's a, whoops. I hope not.
Mr. Kaufman, do you know any songs?
I not only know songs, I cannot operate this pointer either, so bear with me. No, I thought I did, actually. Thank you. Well, just to reorient you, that we all know where the Wedgwood is. We see it every day. It's been there since 1965. It's interesting for me, oh, certainly, I'm sorry. It's very interesting to me. San Antonio and Castle Hills and the surrounding area is a very small place. I had many opportunities to tour and inspect the Wedgwood when we were hired last year. But the last time I was there was in 1967. My grandfather lived there. And it pretty much looks the same. It's clean, but it goes back a long way. But as you can see, we all know where it is. We all know about the fire. There's no one been living in it since 2014, but my client Josh offices there and conducts business there. And in the course of dealing with all the tragedies that happened and the awful things and the lawsuits and the renovation, they're now in a position that they can turn it over to someone that'll restore it to its prior use. We're land use lawyers, and our job is to scrub these things, and we deal with ordinances, and we had to make sure that what was there was legal. And that's when I say it's analogous to the prior case. Unlike the prior case, this building was built in 1965. Your ordinance covering this wasn't done until, I believe, 1995, 30 years later. And to our knowledge, this is de-zoning, and this is the only de-zoning you have in Castle Hills. I think we've verified that. So I appreciate the remarks about amending codes, but this is it. And this was done 30 years after it was built, and unfortunately, the code adopted at that time, I'm sure none of us were here, did not take into account the facts that existed at that time. The time the ordinance was passed, the building varied from the terms of that ordinance. And no one's really thought about it or said anything for all these years. So we've identified 4 areas that, here's another close-up of the building. The grounds, you're more than welcome to go by, are still beautifully landscaped and taken care of. They have a full-time landscape crew. It's got 305 units today. Our proposal is to end up with 305 units. We're not going to ask to increase the number of units. The property was put on the National Registrar this year in 2017. And we're just trying to make your code conform to the building as it exists today. So I'm going to take you through, if you will, the 4 different areas that we need to revise to make it consistent. These items, by the way, have been picked up by potential purchasers. As you know, the building was on one time on the tax revenues for over $15 million. It's about $4 or $5 million today. This is a big project. The people we've talked to plan on spending a minimum of $30 million to renovate that building and bring it up to current codes and modern codes. But one of the requirements in here is the minimum units size requirement. They're roughly, can you all see this very well? Maybe on your screen. We're looking at really D, and it requires 700 minimum square feet per unit. Well, there are 80 units that currently do not meet that requirement. They were built back in the day, and they're kind of, I guess the equivalent would be lofts today. They're 1-bedrooms, very nice, but there's 84 of the 305 units that do not meet that requirement. So we're suggesting or asking that provision be deleted about the minimum square feet. Now, we are willing to commit, however you think it ought to be documented, that we are not going to increase the number of units in the building. We're just trying to make the non-conforming units be legal. And that was our attempt to make it legal. But there's probably a high degree of possibility there will be less units. Some of the people we talked to would like to reduce the number of units and combine units to make them larger, and they certainly would have the flexibility to do that. But 84 units are around 340 square feet, 350 square feet, and these one-bedrooms, it was very popular at the time, and interesting enough, 50 years later, they're becoming more popular. So let's see. The second is lot size, and this is a little confusing, but it's a calculation based on how many square feet you have of property to how many units. You're one of the few cities that adopt that measure. I'm not advocating it's good or bad. We just don't see it a lot. You know, normally a zoning code may say you're entitled 33 units per acre, or 50 or 60 or less, 18 units. But that's just a measurement we're not as familiar with. The challenge for us is that there's been a lot of input from your citizens that they'd like to see some retail on the site. Restaurants specifically were recommended. There's also the possibility for some of the buyers that they may put kind of high-end townhomes on the site. And with that formula, we could not do that. I can go into more detail, but it's terribly confusing. So our proposal is to go from 1,500 feet to 800 feet. Now, this is, again, a calculation based on land size, not units in the building per se, but that was one attempt to give us flexibility. If they wanted to build townhomes, if we put retail uses, we'd have to rezone the property for that. It's not current, D does not allow that, which means you'd have less property available for the residential, and it triggers that. Parking, your current ordinance is we've got it on the board of what your current requirements for parking are. In 2004, they got a variance reducing the number of parking spaces. I'm not sure why that was. We're recommending to really do what forgive me, most of the municipalities around do is a suggestion that you have a range of 1.3 to 2 parking spaces per unit. A lot of times they have on-site parking requirements because they're worried about people parking on the streets in burdening neighborhoods. We obviously don't have that with the Wedgewood. It's also interesting to note that parking requirements over time are going down. And that's because of Uber. You know, some methods of public transportation, people just don't. The old days, you had to have 2 parking spaces per unit. People don't do that anymore. So that's the parking. And the fourth is the front fence. There presently exists a front fence, a fence in the front yard. Just a small technical issue. We just want to make sure that the fence there or any replacement of it is still allowed. I'd put this on the minor category, but again, our goal was take the existing building, bring it into conformity. What do you need to do to make it in conformity? And out of all your codes, these were the only 4 issues that we found. So we suggest for apartments to remove that provision. So I'm happy to answer any questions. It's different from the other case because this is the only dezoning that exists in your city. It was done after it's built. I'm highly confident there was no discussion between the drafters of that ordinance and the people that owned the building at the time to see how it worked. It was just done. No one noticed it. No one's paid attention for all these years. But we're trying to get it in tip-top shape to make it appealing for someone to continue the renovation and to encourage the development of that site in the future. So with that, I'll pause and happy to answer any questions you have.
Before I ask the commission members, let me ask you, so did I hear you say that the applicant you represent is going to invest $30 million in this?
No, sir, the purchaser. They're, Josh and his
purchaser.
partner who've owned it for a number of years, they're not in the business. And 30 million is a significant sum of money, and it takes a fairly large company with financial wherewithal to do that. So the buyer would do that in the renovation of the project.
So I guess I'm trying to get ahead of something that I'm sure, that I know is of concern. So I'm sure we will hear and have already heard concerns from some individuals in our community that this is going to be turned into low rent, subsidized housing, federally supported, et cetera, et cetera, et cetera. And I would like to hear more about what the intent is here, and if you can address what that investment in getting it ready, I think you characterize it in tip-top shape, actually means.
I'll try. This is an issue, our practice is principally from San Marcos down the valley. We do face this issue frequently. I can tell you I'm trying to think how old I am. In the 35 years I've been doing this land use, I've never worked on a Section 8 project. I know what it is. I do know that in many of our zoning cases, we're asked, can we put something in writing that it won't be, to be real frank? And I'll defer to if your city attorney can find out a legal way to do that, we'd be happy to do that. There is federal laws of discrimination that don't allow it, and I've got to be very honest about it. But common sense would tell you someone's going to have $40 or $50 million invested in this. That's too much for one of those kind of projects. We're not increasing the number of units. For typically those projects, they're a bunch of small, little ones. But other than that, I don't know much about Section 8 housing. But I know it's vouchers, and I am highly confident this will never be a Section 8 project, just because of the quality of the buyers that are coming forward and their investment. It's just not it's not a good location, but it's a legal issue that we're happy to work with your city attorney if you need more confirmation than that.
All right, thank you. Let me open it up to the members here. Do you have questions that you'd like to ask Mr. Kaufman at this point? Mr. Flynn?
I have one question. I just want to make sure I'm clear. So you're saying when the ordinance was passed, the square footage that they specified was already larger than what was already existing in some of the units in your building?
Yes, sir. It was built.
Right.
And the ordinance passed that specified minimum sizes of units and total square footage and all that didn't comply with the building that was already built 30 years earlier.
Okay, thank you. You know, I appreciate your comments, and I don't disagree with what you're saying. I mean, it is different. But again, there's some issues here that are somewhat complex, not terribly, but I'd like to be able to think on them a little bit. And that's why we had the zoning committee get together, because they looked at different ordinances from different cities to see how other cities were doing it when they were putting together our changes. So again, I'm going to stand by my original comment that I think that this really should be addressed by the zoning committee, and then we would look at their suggestions.
Okay, thank you, Mr. Flynn. Other comments or questions from the members at this point? Mr.
So
Ventures?
we're to understand, none of the units are changing size here. They're basically being refurbished. All of the units are, there's not going to be any structural changes as far
Oh, no,
as...
sir. In fact, there will be less. For example, there's a penthouse that's really almost the whole floor. that blocks a fire exit, probably not legal. And that will be chopped up into 2 or 3, I say chopped up, renovated, 2 or 3 large. But we think there'll be, we can't predict this exactly, a significant drop-off in number of units. For all the reasons that, and if I may, if you don't mind, may address your comment. I appreciate your concern about picking off the codes. I would say this, that if you consider, we're the only dezoning you're probably ever going to have. You're not going to be wanting more towers. And it's, to us, it's time is money, and we've been carrying it, and I'd ask you to consider that in this case, it's so unusual.
No, I understand exactly what you're saying.
Yeah.
I'm all for going forward with the
Right.
project and putting that property into productive reuse. Just that I'm concerned about the precedent. And
Yes,
I
sir.
understand it probably never happen again, but I like consistency.
Yeah, okay. Thank you.
Any other questions or comments at this point? Ms. Baker?
Can you explain again what you want to do with the fencing? I'm not
There a
100%.
fence exists that technically violates the ordinance, the fence that surrounds the building. It's just an anomaly in your code about, it's really addressed for single-family houses. You don't want people putting fences in their front yard. On a kind of commercial property that's a tower, it's got a perimeter fence around the whole thing, which includes the front yard.
So your
So-
intent is really only to modify the front fence, not the rear fencing?
Correct.
Okay, thank you.
No, the property will continue to be enclosed, for sure.
Okay, if there's no other questions or comments at this point, it's 8:08 PM, and we're going to open up the public hearing on this. Ms. Casey, you've waited, your time has come. Please come forward.
But I will say one thing, that I did have the opportunity to tour the property, and I was pleasantly surprised and impressed, and I think that building has a lot of potential, and it could surely bring in some money for the city.
Thank you, Ms. Casey. I think Dr. Ackley left us. Ms. Winger?
Thank you, Leslie Wenger, 137 Lou John Circle. Of course, I happen to live in the neighborhood that is closest to the Wedgwood, and I agree that it has a lot of potential, but I don't think that we can consider that Uber is going to do or has done anything to get people to reduce the number of cars they have. Just drive around Castle Hills where people use Uber, and you're going to see that nobody is getting rid of their cars just because of it. So I don't think that we should reduce the number of parking spaces required. If I understand, it's 2 per unit. Is that what it is? Yeah. I was aware of the fact that since I had visited people in the Wedgwood over the years, that there were units that were, not 1,500 square feet. In fact, I don't think I've ever been in a unit that was 1,500 square feet. However, I did not know about the 340 square feet, and that's a considerable concern because now you're talking about much lower income people living in that. We did not have that situation when it was senior housing. It made sense to have smaller apartments with senior housing, but I don't think that's the intention. Mr. Kaufman has mentioned various different figures from the purchaser. We don't know where the purchaser is. I don't know whether we should be approving anything without the purchaser being here, because nothing that is said can be held. I mean, we don't, he's just saying this is going to happen, but we don't know who that person is and what their plans are. But if somebody's going to be investing $30 million or $40 million or $50 million, because he used all of those figures, that's entirely possible with federal funds. and those funds will be tied to Section 8 housing. So it's still, as you, Mr. Chairman, raised the issue, that's a concern. So I would be, worried about all of those things, and the fact that before we vote on this, we ought to have some assurances from whoever's planning to buy it, because we don't have that right now. Thank you.
Thank you very much. Is there anyone else who would like to address us? Yes, ma'am, Ms. Jaffet.
Yes, I'm Laverne Jaffet, 12 Shady Cove. I've lived here a long time. I love my area. My kids all went to school here, so it's like home, for sure. I'm opposed to this. There's just too much area that things can't go awry. And of course, if you're I would think, number one, that the number 5 item on here would have to make some amendments just to the way you're asking for it to be changed. I think the Wedgewood being, as it was, for senior citizens is a great, great thing. A lot of people, some of my friends lived there but had to move, but they would love to move back. It were put back together like it should have been. When you reduce this down to 800 square feet, I've been in the rental business for a long, long time. Not big time, just enough to, when it's good, it's good. When it's bad, it's terrible. And when it's terrible, the landlord really gets a hit. And with this area, as popular, I think, as it is, or was, and could be again, you reduce these apartments down to 800 square feet, it's going to bring in, and I'll have to say, our government housing. I have knocks on my little door for my little units that I have constantly looking for Section 8. And they say, oh, we'll do this, and we have to have different kinds of deposits, and this and this and all of this. It doesn't always happen like that, and with this many as there are, I would think that, gee whiz, maybe we could have a big, a whole group come in from wherever, whatever, and have their own little drug parties and this, that, and the other. I know we have laws. Laws are laws. Some of them are great. Some of them can be overlooked. They can be bought out. So under the circumstances, the way this is written, so forth, about changing different sections of our codes and so forth, I believe, and I'm not sure that the law would allow someone to come in and have to say, well, apartment so-and-so can do this, and apartment this over here can do this, and whatever. To make a long story short, I'm completely against this for what it could do to Castle Hills. I can see it turning into Section 8, and once that you sell your property to different, there's probably no laws that can keep you from not renting to Section 8. I'm not sure about all of them, but in my small little grouping that I have, I can certainly have control over not renting to Section 8, and I'm legal. So that's mine for tonight. I am worried about the conglomeration of how big it is, and when the government comes in and lets all these people have, if any of you have ever seen a residence that has had a few of the tenants living in it for a while, I tell you, it'll cure you from renting to those kind of people. Now, if you want to call it segregation, I'm not sure how that works in, but as far as my little deal with, the landlord has the proof, or he has the authority not to rent to that. But as big as this would be, I'm sure there are other laws or rules it could. But just to think about having the Wedgewood go into public housing would be a disaster. Thank you.
Thank you, Ms. Jeff. Is there anybody else who would like to address the commission tonight? Yes, ma'am.
My name is Suzanne Riley at 102 Iron Gate Road. 305 units?
I'm sorry, Ms. Riley, I can't
305.
hear you.
305 units?
Okay.
300 to 305, somewhere in there.
Is that currently?
That's correct, and it's going to stay at 305 more or less?
Yes, ma'am. We're willing to agree that they won't increase the number of units in that building.
Okay. And you said there's units right now that are at about 300 square feet, you said?
340.
340. Wow. Okay. 84, did I write down the right number? 84 of them? So that, sorry, okay. So those 84 that are right now at 340 or thereabouts, they're going to go, if you get approval, they're going to go to a minimum of 800 square feet? What does it mean?
They're going to stay.
Ms. Riley, in the interest of the audience being able to hear that, can you address your questions to the commission, and then we'll ask Mr. Kaufman to come up
Okay.
to the microphone to answer them so that everyone can hear?
I guess I thought that if it changes to a minimum of 800 square feet, then there's nothing going to be in that building that's less than 800 square feet. Am I not thinking about that in the right terms?
Say that one more time.
If the proposal, or they're asking to go from our minimum of 1,500 square feet to a minimum of 800 square feet, then whatever is under 800 square feet needs to come up to 800 square feet. Is that correct or not?
Okay, now let me ask Mr. Kaufman to come back to the microphone to answer that. Thank you.
I can understand why it's confusing, but you're talking about two different sections. Okay. The first section. I'll do my best. No one has ever complained that I don't talk loud enough or often enough. The first section deals with unit size. Actually, as you were talking about, the 340 square feet or 800 square feet. We then talked about lot size. And it's a calculation that your staff would do to determine, because of the size of the property, how many units you could have. And there's a formula that does deal with we recommended 800 feet per dwelling unit. It's not the actual size of the dwelling unit, it's that formula on a piece of property that big. So essentially the units are going to stay pretty much like they are. Each buyer has a different plan. Some may want to take the 340 units and combine them with 2 and make them larger. Some may want to keep them the same. But the units are not going to be a minimum of 800 square feet per unit. That is a lot size. If you look at the title at the top, I knew this was going to happen. It talks about lot size, and it is a formula to determine how many units you can get based on the size of your property. And I could bore you with the calculations if I can, but it's not the actual unit size. It's a lot size.
Okay.
I apologize.
No, thank you. Ms. Riley, did you have other questions or comments?
Is there any way to know now how many units are going to be, because I'm looking, I'm a landlord, I own other properties than here in Castle Hills. Is there any way to know how many units in that building would be under, let's say, 800 square feet per dwelling unit?
So for the sake of this conversation, again, Ms. Riley, why don't you go ahead and address the questions to the commission in your entirety, and then we'll have Mr. Kaufman come up, explain it, and then if you still have questions, we'll be happy to accommodate that, okay?
I guess that's my concern. And now it's a little clearer. I thought that the dwelling unit itself was going to be, the minimum square footage was going to be 800 square feet. Now come to find out that's not the case, and I don't know how many units in the building existing are less than 800 square feet. Even if we're not going to have a change in total units available, now I don't know what this building's going to be. I was hoping that whoever developed this was going to develop a high-end situation where probably most of the people that live there would probably have come from Castle Hills, who don't want their big yards, who don't want their pools to deal with, and it would have been that situation. But now I'm even more concerned when I find out that 800 square feet is not going to be the minimum size of an apartment there. So this is giving me pause, considering the fact that when you looked at the map of where the Wedgewood is, that cul-de-sac that you see butting up against there, that's my cul-de-sac. And that's my alley going right next to it, right there. So it does give me a little pause to figure out that it's not going to be, gosh, and how do I even say this? I can't imagine living in 300 square feet. Thank you.
Thank you, Ms. Riley. All right, Mr. Kopman, you want to address that, and then we'll see if we have any other public comments.
For 50 years, the unit size in that building existed with no complaints. For 50 years, from 1965 to really 2014. And it caused no problems. The comment about Section 8 housing, I wasn't going to get into that. They get, yes, ma'am. Section 8 housing typically is 3-bedroom-size units. So we had one speaker saying, you're going to have Section 8, but there's no big 3-bedroom units. And it's really the way it is what it was when it was built, and it served y'all well. It was a good neighbor. It was a good citizen. We're just trying to attract a quality developer to come in and spend a lot of money to fix it up. Now, the truth is, if you deny it, they can still develop it, okay? Those units will still be the same size. It just won't be the same quality. And it's a self-fulfilling prophecy. To get it cleaned up for a quality developer who's going to spend millions to buy the building and then 30 million plus to fix it up, they want these questions answered before they start. If y'all elect to say no, then it'll be what it is, what it is. And we're really trying to build a quality project, and hopefully you'll agree. And we're happy to limit the number of units. The size really doesn't matter as long as the unit count does increase. I mean, they want to have enough units, and as long as they're not more than exist today, they're not going to get smaller, and if anything, they're going to get bigger. We have a problem doing that under your current zoning structure, that we really have non-conforming uses, and there's a question of what can we do moving walls. So you're giving a developer the flexibility to combine units, to reduce the number of units by moving walls. If ultimately the city decided it didn't want to amend the code, then it is what it is.
Okay, thank you, Mr. Kopman. Are there anyone else in the audience that would care to address the commission tonight? Ms. Casey, round two.
Well, I want to say that I think that it could definitely be a Class A apartment or a townhome. And we surely do not want it to remain it is as it is. So I'm all for trying to work with them to get it dezoned, rezoned, or in order for a developer to come in and purchase the property and make it something that Castle Hills would be proud of. Can we word it to where we would zone it as a Class A property? We don't have to say it can't be this or that. We can say we can zone it as a Class A property. There's got to be some way that we could word it to where we could move forward with this property and get it moving.
Okay, thank you. All right, is there anything else before we close the public comments? Okay, Ms. Winger. I want to get the commission to actually take action on this tonight, so please, as you're coming for round 2 here, if we can keep it brief and give the commissioners a chance to actually get into the rumble here. Yes, Ms. Winger.
I'm always brief. Just in answer to what Mr. Kaufman just said, I don't think that they're trying to develop a quality property. What they're trying to do is give a potential buyer the flexibility to do whatever they want. That's my concern. I agree with Ms. Casey. We want a top-notch building, such as the Wedgewood has always been. And we need some assurance that that's going to happen and that it's not going to be something else. The only way to get that is for them to bring their purchaser in. Thank you.
Thank you. All right, Ms. Jaffet, you get the final word from the audience tonight.
Well, I'm going to be short and sweet. I just think that our item number 5 that we're working on,
Yes,
I don't believe it could be applied the way that we've been discussing it. I just don't think that that's the right, you're not asking for what is written on here, or you are getting what is not written on here.
Thank you, ma'am. All right, thank you all very much for your input. We appreciate that. It's 8:28 p.m. We're going to close the public hearing now and resume our meeting, and we'll open this back up to the commission members. Is there an initial round of questions or comments that anyone would like to offer? Mr. Flynn?
I'll just make a comment. I just want to clarify again, Mr. Kaufman, these changes you're requesting reflect what the building layout exists now, okay? Now, having said that and confirmed that, I'm all for putting this property back into productive reuse. It's a prime location. I think if I was an investor, I would want to develop it based on its location. I think I could make a lot of money. I'm not in that line of work, but I can see a mixed-use development with restaurants and retail in the first floor, and then high-end apartments and townhouses or what have you throughout. But again, there are some issues that have caused some confusion here, as we've seen. And again, I think that goes back to my initial position, is that why we need to have the committee that we put together review this ordinance and let them present it to us. And so, again, as much as I'd like to see this put back into reuse in a very productive manner, I still want to set a precedent and maintain a process and stick to it. And so I'm going to vote no.
All right, thank you, Mr. Flynn. Are there other comments or questions, discussion? Mr. Fentress?
A couple. I think the fact that the application stated the sizes of the parking and wasn't very clear that they were trying to get approval for the existing 340 square foot units caused a lot of the confusion. And it worries me a little bit that we were not very forthcoming about the size of the 340 square foot units, because probably realized that wouldn't be real popular. My first apartment was a convenience apartment, and it was 760 square feet. They didn't even call it a one-bedroom. And so I know, that's extremely small, and I don't think that was a problem when it was a seniors area, but it's not, to my understanding, going to be restricted to being a seniors facility any longer. And we're not San Francisco or Manhattan, so there's no guarantee that a 340 square foot unit is going to go at a premium. So I think that's what's causing some of the concern from the neighbors. So I totally get that. I'm concerned, though, that our job is to address the zoning and not restrict the uses. And I'm wondering if there are ways to cover their concerns that may not really be coming from us, but from other parts of City Hall, Castle Hills government, because I don't think we'll ever be able to promise them this is what they're going to do with this square footage. But there can be are there other avenues where we can ensure that, how do I put this most simply, that the building doesn't get built on the cheap?
So I think your comment, if I hear it correctly, would be more of a question aligned to, would there be engagement by the Board of Adjustment, Architectural Review, city staff, others that would give you the assurance, if you will, of the standards to which you believe it should?
Sounds better when you say it.
But that's, well, now I'm just trying to frame that up because I want to see if city staff wants to comment regarding if we extrapolate a little bit about where this would go. What are, for those who don't have the benefit of doing this every day, like what are some of the other obligations, expectations that they would encounter?
So this is just one of the paths that they could have gone down. They could have gone and applied for variances to the zoning code, and we discussed that as a possibility. Some of these, I believe, already are pre-existing variances. I heard they have one for parking, changing it to 1.0, and my understanding is the variance goes with the property. So, so yeah, they could do that. Architectural Review Committee would certainly be reviewing this and determining and kind of scoping and shaping what that development would look like to a certain extent. So there are other processes that would come into play on this as it went through. I would like to comment just quickly on the Zoning Review Committee, which Mr. Flynn has mentioned several times. Currently, it's not active. They've made their recommendations to the Zoning Commission. And the reason that this action and the previous action have been brought before the Zoning Commission is it's kind of a needs-be item. You know, it's not something that was forecast at the time of the Zoning Review Committee actually convening. So we'd have to reconvene them, which we could do. But that's the reason why the process seems a little bit screwy to you, Mike. But yes, they would go through some level of scrutiny through other city processes, Mr. Fentress, absolutely. Mike, do you have anything to add to that?
Mr. Chairman, this is one of those examples that if this thing could be done through an SUP, the city would have total control over what happens. But that is not projected or requested, and it's not in the code as it exists right now, so I don't think we can do it at this point in time, but it would sure work for a project like this.
Thank you, Mr. Brennan. Are there other comments or questions? All right. Did you have one, Mr. Aiken? Or were you just trying to play with the microphone?
I got it. Bill, you're an attorney in town, correct? And is this Scott sitting next to you? Scott?
Josh.
I'm sorry. Are you one of the owners of the property? Would you mind if we heard from one of the owners? Just why don't you tell us in your words? I work with attorneys all the time, and I know what they say, and you really did a good job. But Scott, why don't you tell us what you're doing? And tell us tell us what you think the plans are. I want to hear it from you.
I'm Josh Barudine, property owner. I've owned the property since 2013 in August, probably about a year and 3 months before the fire happened. It was an unfortunate event, went through a lot to get to the building where it is today. Just cleaned up, continued to maintain it, to have it showing well not only for the city, but also for the people, and also for myself and my potential buyers. I work with Janet all the time if there's any ever issues that come up. I'd like to think that we take care of them quickly and timely and keep maintaining the property as it is until we get to this next step. Now, I've spoken with many developers and potential buyers, and this zoning is a huge roadblock to them even wanting to spend time on it. Because for them to want to spend time, that's money. And for them not to understand they even have the zoning to do what they can do, a lot of them walk away. And it kind of leaves the building where it is now, almost 3 years later, without a clear answer. And I wish I could give you one, but I can't. Because I don't have that buyer right now. The ones that we've had have continued to move on, or tell me when you work with the zoning, you finalize the zoning, let's talk. And that's why I've engaged Bill Kaufman and his crew to come and help me get the zoning through. we're not asking for any changes to what the building is currently what it currently has today. If you drive by it today, there's a perimeter fence in the front yard. That was put in, I'm not sure how long ago, but the city was okay with it, and it keeps people from walking through the property of the private residences of those folks at Wedgewood. It's there today, and any developer is going to want to keep that. And the zoning today would not allow that. They wouldn't have confidence that that fence would stay. The building, size of the lot, the size of the units compared to the lot size, it doesn't really apply to a high-rise building. The code that was adapted really is more for the garden-style apartments where you have 10, 15, 20 buildings on site. You have a lot of sidewalks, you have a lot of porches and balconies, where you're going to be required to have a lot more lot coverage than a high-rise building with very little sidewalks, very little land. As you can see, this building, it's probably about 2 acres of actual building surface. You have about 4 acres of parking lot and 2 acres of the backyard. What's really going to sell this building as a high Class A development, a very nice facility, is going to be all the amenity space. Those 2 acres in the backyard, for those of you that have been able to walk it or tour it, shows very well. And that's really going to set this place apart as something to really sell not only to tenants but also for the community. The unit sizes. There's minimums that were put in well after the building was built. There's about 84 units that are about 350 to 400, depending on what tape measure you're using. They've been there for 50 years. Those very popular unit sizes from then until 2014, they're popular with what I see in apartment deals in San Antonio and Austin, because the higher end tenant, the ones that want to be there with a fully amenitized backyard, the nice fitness centers, the gyms, the movie theaters, they live in the community with their friends. They don't live in their apartment. They bring them in to socialize around their apartment, and they don't need that 1,500 square foot unit. You really don't see that. The only places you see those large 2-bedroom, the large 3-bedroom, 4-bedroom units are going to be your low-income restricted housing in your Section 8. Those are really developed, those large units, for the large families, the families that have 2, 4, 6 children, and they can barely pay their rent, and they're at those houses. And that's why the Section 8 is there. You don't really have that being built for affordable units this small. Now, I'll tell you that the 84 units that are about 350 to 400 units, you also have about 150 one-bedroom, one-baths that are between 700 and 770 square feet. And if you look at a lot of the newer developments today, and when I say today, 2012, 14, 16, when construction was starting to ramp up again, you're going to see a lot of 500, 600, 700 square foot bedrooms. And that's just kind of the nature of it now. People are really looking for that amenity space, and that's what Wedgewood could be. So of all the 4 items that we're asking for, let me address the parking. We haven't got to that yet. About 2/3 to 3/4 of the building are the studio units and 1-bedroom, 1-bath units. You don't need 1 full parking space for these units. Most of the time they are single occupants, and not all of these single occupants do have vehicles. Most of them do, but not all of them do. The 2 per unit is really for the larger units when you have a lot more 2s and 3 bedrooms. So that also is why we're asking for that not to be, to bring it back down to what the building is currently having. I think there was an amendment or a variance passed a few years ago to allow for about 300 parking spaces. We're looking to take that up to about 400 to provide a few more spaces for the building. So again, what we're asking for is to meet the zoning with what we have today, what we've had 5 years ago, 10 years ago, and 50 years ago, which is also very adaptive to what some of the newer developments are being built.
Anything else, Mr. Aiken? That was your question.
No, Josh, you have good presentation skills, so thank you.
I have a question.
Mr. Ventures?
In the year and a half that you owned it before the fire, was there a separate or combined maintenance fee for the units, the different size units? Or was that combined with their rent?
No, they were technically an all bills paid apartment. The residents did not pay a separate water bill or electricity bill. It was all built into the rent. They had to maintain nothing but, keep their fridge stocked. The property owner took care of light bulb changes, plumbing leaks, all of that. There was no additional maintenance expense.
So after remodeling, there's going to be a fairly significant maintenance fee, even on the smaller units, to maintain them, to pay for all of the grounds and maintenance, the building maintenance, and the other amenities you were mentioning. There's still going to be, even with a new owner, there's still going to have to be a joint maintenance fees for even the smaller units, especially with remodeling involved in a building that size. Is that correct?
There's really no maintenance fees. It's all built into the rent. I think the operating expenses will actually be lower once the building is completed again. You're going to have much more efficient units, much more efficient utilities, much more efficient HVAC systems. The actual expenses will go down overall for the building.
Are there other questions or comments? Mr. Flynn?
Yeah, after the discussion here, and I've reread the change, so what you're really, you're not amending the apartment size, you're amending, right now you're saying you have, your lot size are just too small for the number of units that you have in the apartment. I mean, you're wanting, your current lots are less than what the ordinance requires, because you're saying you need 15, you want to reduce it from 1,500 square feet to 800 square feet per dwelling unit. So I'm assuming that right now you're in violation, basically, of the lot size ordinance. When you talked about the low-rise apartments, that's what triggered it for me.
Right. Right now, we're out of compliance with the current zoning.
Okay.
50 years ago, it met everything. And,
Right.
and there's the
So
zoning
you're
that was put
bringing
in
it
place.
into compliance, I guess.
We want to
Or
bring the zoning.
we would bring it bring you into compliance.
That's correct. We want to bring the zoning to meet the building what it currently has today.
And there's a good possibility that these really smaller units, you might combine them to make a larger unit, correct?
There's some of the developers, not all, have
Yeah.
discussed maybe combining a handful of them. Now, that's not 100% of them. There will be 350 to 400 square foot units.
Mhm. I have no more questions.
All right, thank you, sir.
Thank you.
If there's no other questions or comments, we'll open it up for a motion. Is there a motion?
I'll a quick comment. Sure. I don't have a problem with the fence. I understand the lot is basically a formula that's an old formula that doesn't necessarily mean anything one way or the other in conjunction with the Wedgwood. And the, what was the third thing that was, the automobile thing. I understand from past experience in my business that I don't think a two-car, I think that's excessive and things. So those three things aren't even issues personally. Just the size of the units versus the quality, the only thing that makes me uncomfortable is, losing control over what might happen with some unforeseen buyer as to what will happen with those the smaller units. Where I was going with the monthly rent thing was I was hoping after all the remodeling that you're going to need some maintenance fees to keep that the quality up, that somebody that's paying those is not going to be buying a cheap unit there. But, and I still think that's probably going to be the case. Things cost more than they did when that was first built. But that's my sole issue there is just simply the square footage of it. The rest, as we said, has always been there. In fact, all of it has.
It seems to me it's a little bit of a catch-22 that we would like assurance, and I don't think it's unreasonable to ask for assurance on what's going to happen there when you talk about hundreds of units. And you can speculate to one direction, you can speculate to another, and we've certainly heard some of that. But, you know, the reality too is that, you know, if where it is now, if nothing is done, it continues to sit, right? It continues to be abandoned basically in its current condition. We don't have the developer to come before us to say, this is what the plan is, this is the assurance that I could give you on that. And that's not going to happen anytime soon, which I think too, where part of your question before was relevant is, so what protections does the city have, or what peace of mind could the public have given this uncertainty? And I live right around the corner. I know a number of the people in the audience tonight here live right around the corner, and I had always kind of planned that when I'd get old, that's where I'd move to. And now I'd like to think about when all the hip young people move there, that I could go live with them instead. And I'd love to have the assurance. I think that's what we would like to have tonight, is some assurance on it, but we're not going to be able to get that. So the question is, to me, do these changes or these proposed changes to the zoning commission or to the zoning ordinance really alter anything that shouldn't already be in place? Because this isn't going to be a one step to completion. This is going to be, this step would need to be taken, another step would need to be taken when we get to talking about development or the developers or the buyers or whatever. So I don't think if we're looking to solve every problem or address everything tonight, it's humanly possible to do that.
Mr. Chairman, let me also add that the zoning change that they're requesting has nothing to do with the square footage of the units. It has to do with the lot size of the area surrounding the building itself. Right now, the ordinance says that you have to have 1,500 square feet per unit, and apparently they don't have that. So it's not, they're not requesting a change to the unit size, it's the lot size.
That's correct.
Well, they're trying to bring the units in line, size of units in line with the zoning.
Well, they're trying to bring the lot size in
No,
line
both.
with the square footage of the units.
It's basically the reset here of where it should be to be in compliance with our zoning ordinance.
Right.
Then what happens?
And the zoning
happens.
ordinance was passed after that building was already in place.
Mr. Chairman, can I make one
Yes, sir.
comment? That was not a correct statement that was made. They're asking a section 50-225 change, which would eliminate the minimum square footage for each apartment. So there would be no minimum square footage per apartment.
Is that just for high-rise?
Yes, it's in this zoning district only, this D high-rise.
So the other thing, just again to kind of try to frame it, is this is a ordinance that applies to one structure. So, and I'm not trying to advocate to you one way or the other on this, but this ordinance is solely focused on that one specific piece of property there.
But again, they're reducing the minimum lot area based on 1,500 square foot.
So in other words, there's two that they're requesting. One is to eliminate the 700 square foot per apartment requirement, and the other is to eliminate the 1,500 square foot per unit requirement.
Okay.
So it's both the lot size and the minimum size for the apartment.
Okay.
I don't love completely eliminating the minimum square footage there, even if we've only got one of them. That poses not a big problem, but it's leaving a door wide open. Well, if I say minimum 340, I can lean to my left here and know exactly what problem we're gonna have. We're gonna be one off and again. If I say that it has to be 340 square feet minimum, we'll be, you know, we've only got one of these, so everything we do is a one-off, unfortunately.
Mr. Kaufman, did you want to comment?
I was just going to remind the commission that we're not increasing the number of units. So that's the gotcha on that. that it is what you've got it now, you've got 305 units. If you make one smaller, then you're still going to have 305 units. So that's the test. You'll never reach the situation you're concerned about. You know, I guess we're just pleading at this point that we were legal when built. By action of the city, we wouldn't be here. If somebody would have called them and said, here's what, hey, be on a committee, we're getting ready to rezone your property, it wasn't a zoning case, okay? And so I think Josh did a lot better job than me trying to have what he has be legal. And we'll try to get whatever safeguards that are reasonable that we can legally do, of course.
All right, I'll entertain a motion.
You want me to try again? Oops. Where's that cord at?
It only runs that big.
All right, so I will make a motion to approve the repeal of section 50-225-3, which establishes a minimum size for apartment units, to amend section 50-227D3 by reducing the minimum lot area for high-rise apartments from 1,500 square feet to 800 square feet per dwelling unit, to amend section 50-227F by reducing the minimum off-street parking spaces required from 2 cars for each dwelling unit to 1.3 cars for each dwelling unit, to amend section 50-228A by exempting front yard fence height limitations from the applicability of section 50-66 to the D high-rise apartment district, and by repealing section 50-28B.
And that would be a motion to recommend to council, right?
Yes.
Did you repeat it, but say that at the beginning?
That would be a motion to recommend to council.
Now read the rest of it. All right, we have a motion. Do we have a second?
Second.
All right, we have a motion, second. Is there any other discussion? Hearing none, all in favor of the motion as presented by Mr. Aiken indicate by raising your hand. It's unanimous. Thank you very much. This is a recommendation that will go before the City Council next Tuesday for its final action. With that said, it's 8:53 p.m. We are adjourned. Thank you, commissioners and audience members.